Thank you, everyone. Before I even begin, as part of cultural protocol, I have to acknowledge country. And not only do I want to acknowledge country, but I want to honour country. For a land that has sustained and fed and nurtured my people since time immemorable. Are there any First Nations mob in the crowd tonight? I can see a couple of hands. I just want to honour you as well. And I want to honour the Darug Nation. My country is just over the Blue Mountains, and I know we would have shared a lot of connections before colonisation, and we still share it now. So as I begin, I'd like to say, Gowambana, Yama Dumarang, Yuan Yandi Taylah, Baladu Duramandilanya Baradriyina. Hello, how are you? Are you well? My name is Taylah, and I'm a proud Wiradjuri woman. I'm here today to tell a message of truth. In my language, we don't necessarily say, speak the truth, but what we do say is a concept called Gariyala, which means to speak from the heart. Today, my truth comes from not only as a PhD and lawyer, doing a PhD and my work as a lawyer. It doesn't just come from that, but it comes from my perspective as a Wiradjuri woman. And in my genetic disposition, all I wish to do is take the best possible care of Mother Earth. When I look at Mother Earth, when I look at the land, I don't look at her through the lens of a commodity. I look at her as a living relative, because that is part of my kinship. Native title doesn't allow me to do that. But what is native title? Native title is the legal recognition that Aboriginal and Torres Strait Islander people have the right to use the land. And that's it, simply use the land. It means we can hunt on the land, we can fish on the land, we can practice cultural traditions and our law on the land. But it doesn't allow us to mine the land. It doesn't allow us to sell the land. It doesn't give us veto power, which means we can't make any final decisions about the overall well-being of the land. The concept of native title came through a decision as what you may know today as the Mabo decision, which was an outcome that happened in 1992. It is the first time that the highest court of Australia overturned the incorrect legal myth that this country was terra nullius, a Latin term meaning a land belonging to no one. Though the victory of Mabo was short-lived by my people, terra nullius may have been overturned, but the ghost of terra nullius still lingers within the realm of property law when considering my people's rights to land. So where does dispossession live? I asked myself as a naive undergraduate student at the time, angered by the fact that I couldn't come up with an answer to this question, angered by the fact that my people have sent numerous petitions and letters of concern to the address of dispossession, and yet her address remains unknown. So I sat with this question of, where does dispossession live? Because maybe I would make sense of it one day. Maybe I would find an answer. Australians must ask themselves, what is native title? Why am I so fearful of it? Does this mean I'll lose my land? And I'm here to tell you, no, it doesn't mean you'll lose your land. In fact, native title can only be claimed over Crown lands, New South Wales government lands, and not private lands. That's not what Mabo did. Mabo gave us the right to use the land, to hunt on the land, to fish on the land, to practice cultural laws on the land. To reiterate, we can't sell the land, we can't mine the land, and we can't make overall decisions about the well-being of the land. But the rights initially created in Mabo would never be experienced by 21st century native title claimants today. This is because the rights to fish, to hunt, and to practice customary laws were fractured by later High Court decisions, legislation, and Western literature. Make no mistake about it, all native title has done for my people is dispossess us. So I continuously ask myself, Where does dispossession live? And what the hell happened to the rights established originally in Mabo? Well, I can tell you. Native title is just a mask for dispossession. And this dispossession has been achieved through what Professor Robert A. Williams Jr. suggests as the language of savagery. This racist, savage language has been used by the West to justify the displacement of my people. And this language of savagery is reflected highly in Western literature. And because of this, European systems were placed above our systems when considering the use of land. Quite often their literature has referred to us as the lowest class of human beings, subhuman, the weakest evolutionary link between man and monkey, an uncivilized race incapable of cultivating any form of property. And Australia still speaks this language every 26th of January, every single year when we celebrate Australia Day. The official day that terra nullius was declared on this land. In fact, the colony will go as far as implementing legislation that funds projects that amplify this discovery of Australia. And they did this. They did this with the Australian Bicentennial Authority Act in 1980. And thankfully it's been repealed. And because of this overuse of this language of savagery, it again provided a basis to dispossess us. And despite Mabo, and despite the overturning of terra nullius, this legal system still uses that same language of savagery every time a native title application is denied. After the Mabo decision, people were running around mad. What did this mean for them? But the Native Title Act was implemented in 1993. It provided a legislative framework that Aboriginal and Torres Strait Islander people had to prove in order to establish a successful native title application. One element of this act was that Aboriginal and Torres Strait Islander people had to prove continual connection to the land, continual connection, which is often a difficult element to prove these days, considering we were subjected to over 200 years of displacement, stolen generations, the assimilation policy, the ecological violence inflicted upon our land and our non-human kin, and climate change. This is the language of savagery in legislative form. The fact that we have to prove that physical continual connection to something that was ours from the get-go. Dispossession also hides in the case law. When we look at a decision back in 1996, known as the Wick People in Queensland, 3 years after the Native Title Act was implemented. And this was a decision that dealt with competing interests, where you had a successful native title group and pastoral leaseholders who had the same interests in land. And the High Court had to decide this issue of what happens if there's a conflict between these two interests. Ultimately, the High Court ruled in favour of the pastoralists and it extinguished native title. But what it never answered is the question of extinguishment and whether that extinguishment meant it was suspended or it was permanent. So 2 years later, there was a decision though that did answer this question. It was the decision of Fijo and the Northern Territory. And what that case basically said was, when there's two competing interests, native title trumps, it's gone. And when it's gone, it's not suspended, it's gone forever. No more native title on that land. And then as a response to the Wick decision, you had greedy corporations running around wild thinking, what does this mean for me and my companies? So then we implemented the Native Title Amendment Act as a response to the Wick decision. And make no mistake about it, in the second reading speech, they used this language to produce bucket loads of extinguishment of native title. And it listed a range of commercial interests that would trump native title forever. This is the language of savagery in effect. They would rather extinguish our rights to the land than to suspend our rights to the land. And then we had the decision of Commonwealth and Ymir, which came later in 1999. And this considered our rights offshore, rights to the seabed, which is something that Mabo and previous decisions never considered at all. And Ymir said we could use the seabed for individual purposes, for cultural practices, but we couldn't cultivate or farm the land for natural resources in a commercial quantity. They deprived us of the economic opportunities embedded into those native title lands. This is the underlying savage language that feeds our dispossession under native title. And then, of course, we had the decision of Yorta Yorta in 2002. And there was one particular piece in this judgment that was so detrimental to later native title applicants. And it said this: the tide of history has indeed washed away any real acknowledgement of their traditional laws and any real observance of their traditional customs. The foundation of those ancestors have disappeared, and the native title rights and interests previously enjoyed are not capable of revival. What did this mean? It meant that one day, First Nations people will no longer be able to prove their continual connection to the land. And as a result, native title would disappear with it too. But limiting communal rights to the land is not something that colonists just practiced as soon as they showed up onto these shores in 1788. They've been using this savage of language in the peasant economy, in the English law, prior to landing here. And we know this with the decision of what's known today as Steele and Houghton, which is a landmark decision in English law. And it's considered the great case of gleaning. For you who aren't too familiar with what gleaning is, it's the practice of collecting leftover crops of grain on a private field. And this is the way the peasant economy created their income and fed their families. And the outcome of this decision ultimately said that the peasant economy are pest. And they ended up, the House of Lords ruled in favour of the private landowners. I worry one day that this land will become so privatised that communal access to the land is just a thing of the past. But communal access to land, it affects and it has affected everybody. In closing, I want to say this. All I want to do is take the best possible care of my country, of my Mother Earth. Native title doesn't allow me the right to do that. Native title never was for us as Aboriginal people and Torres Strait Islander people. It was for the Crown to maintain control over our waters, over our lands, and over our resources. And after all these years, I finally figured out the answer to my question of where does dispossession live? And now I know. Dispossession and native title have the same address. Thank you.